Motion for relief from judgment. Comes now, Paul Allen Fiscus 3, petitioner, and pursuant to KSA 60-260, b. 4, and the 14th Amendment, hereby moves this court for relief from the judgment that illicitly terminated his parental rights to his daughter on March 8, 2019. Judicial deception is fraud on the court, which violates due process and disallows subject matter jurisdiction. Any resulting order or judgment is void, and is void even before reversal, having no legal force or effect. If necessary, a void order or judgment can be repeatedly challenged since no judge has the lawful authority to make either valid. Turner v. Godinez, Case No. 2015 CV 0343, 426, ND Ill August 11, 2017. It is fraud where the court is corrupted, where the judge has not performed their judicial function. Bullock v. United States, 763 F.2 D 1115, 1121, 10th Sir 1985. The derisive abuse of power in this case is antithetical to due process and to the rule of law in every way imaginable. Fundamental rights were pusillanimously violated where, during the trial ruling, the mother's perjury, deceit, and mental unfitness were overlooked. Example: he did not specifically ask me how I was feeling, no. RV, 151-52, a number of direct falsehoods were stated. Example: there were times that she was without residence. Several scapegoatisms were purported. Example: his texts were abusive, sarcastic, mean, and self-centered. Testimony and evidence were misconstrued. Example: he was not emotionally supportive. The language of an unconstitutionally vague statute was misinterpreted. Example: the statute does not let you make that decision. Fraudulent actions were corroborated. Example: it has affected his everyday life and work. Procedural law and precedent were disregarded. Example: the mother's refusal of support, and parental fitness was sordidly wielded, where, pre-trial, multiple illogicalities were made. Example: he did not have custody of the child pre-birth. Scores of artifices occurred. Example: the initial petition for adoption held no factual basis, and numerous professionals had devised fabrications. Example: it appeared he was trying to position himself to where I was not able to see what she was doing. R4, 172, emphasis added, where the appellate courts echoed the effete incivility. Example: but mother did accept other offers of support, where a pertinent motion free of a time restraint was denied by this court due to time limitations, followed by a felonious dismissal of the subsequent appeal, and where valid revisions were then submitted to this court but contemptuously ignored. In readoption of AAT, 287 Kansas 590, 598-99, Kansas 2008, a judgment is void if a court acted in a manner inconsistent with due process. A reviewing appellate court must apply a de novo standard. Courts have a mandatory, non-discretionary duty to vacate void judgments. Atten v. Barnes, 158 WN. App 343, 350, Washington CT App 2010. It is axiomatic that fraud vitiates everything. Correspondingly, lack of jurisdiction over subject matter can be raised at any time. Chalmers v. Burrow, 58 Can. App 2D 531, 539, Kansas CT App 2020. The right to a fair trial is a fundamental liberty secured by the 14th Amendment. Estelle v. Williams, 425 U.S. 501, 503, 1976, Drope v. Missouri, 420 U.S. 162, 172, 1975, et al. Justice must satisfy the appearance of justice. Levine v. United States, 362 U.S. 610, 616, 1960. The Due Process Clause avers that no state may deprive any person of life, liberty, or property without due process of law. U.S. Constant Amend. 14, 1. Judicial independence does not equate to an unbridled discretion that disregards the requirements of the law or ignores constitutional rights. Discipline of Hamar Master, 139 WN2D 211, 233-34, Washington 1999. It is a central tenet of American jurisprudence that no one is above the law. Guru Nanak Sikh Society of Yuba City v. County of Sutter, 326 F sub 2D 1128, 1135, ed. Cal 2003. T. District Court did not abuse its discretion in determining the natural father, by exercising reasonable diligence, could have discovered the natural mother's lie about obtaining an abortion and her concealment of the birth and adoption of their child. In readoption of AAT, 287 Kansas 590, 629, Kansas 2008. Strikingly inconsistent, the Baby Girl P Court also rejected the criticism of the father's failure to discover the mother's deception about a miscarriage. And the court went on to explain it would not read into the statute a requirement that a father invade a mother's privacy to determine whether she is pregnant when he has sound reasons to believe that she is not. In Re CL, 427 P.3D 951, 960, Kansas 2018. The fathers in CL and Baby Girl P are African American. The father in AAT is not. The racism is undeniable and abjectly intolerable. The initial petition to terminate parental rights referred only to possible fathers, and what they were expected to do. An attorney may not include allegations in a petition without factual support. In Re Kenny, 490 P.3D 1194, 1202, Kansas 2021. The petition for adoption should have been dismissed immediately. Ensuingly, all the relevant surrounding circumstances must be considered in an action based on KSA 59-2136, H, 1, D. In readoption of BBM, 224p.3 D 1168, 1174, Kansas 2010. This subterfuge was derived from an egregious omission of the relevant circumstances. This court, he was able to buy a house. July 1, 2018, I just bought a house with my main intention to accommodate my daughter. RX, 337. He spent money. That was more important at that time, at least he believed, than the child that was being carried by the woman. My daughter is the most important thing in this world to me. RX, 282, 305, 309, 315. For most of the pregnancy, the mother had no financial obligations while living with a boyfriend. Did you charge her rent when she moved in with you? No, RV, 252-53, 255. Unquestionably, a mother's needs are a relevant circumstance. In re of the adoption of MDK, 58p.3 D 745, 749, Kansas CT App 2002. To insinuate that anything was more important to petitioner than his daughter at any time is profoundly vile. He gave her no means of transportation, but to be fair, he did give her a couple rides when it also benefited him. It is exceptionally unprincipled to place false blame on a conscientious father who had indeed satisfied the statute's intended requirements. At no point did he somehow benefit from his actions outside of providing support for his unborn child and to her mother. When an unwed father demonstrates a full commitment to the responsibilities of parenthood by coming forward to participate in the rearing of his child, his interest acquires substantial protection under the Due Process Clause. Lair v. Robertson, 463 U.S. 248, 261, 1983. Adoption is for children who do not already have parents. If a child has a willing and able parent, then adoption is not in the child's best interest. After all, adoption is about finding families for children, not about finding children for families. Seymour, Ethical Blind Spots in Adoption Lawyering, University of Richmond Law Review, Volume 54, ISS 2, 521, 2020. Unavailingly, petitioner has spent thousands of dollars and hours to restore justice and his family. It is arrogantly injudicious to continue disrespecting a devoted father who will stop at nothing to protect his child and their rights. It is the civic duty of each U.S. citizen to defend the Constitution and U.S. laws against all enemies, foreign and domestic. Every studious U.S. citizen also has a moral responsibility to disobey all unjust laws, orders, and judgments. But more than anything else, petitioner has a moral and sacred responsibility to his daughter. Conclusion: a trial court abuses its discretion if its decision is 1. Arbitrary, fanciful, or unreasonable, 2. Based on an error of law, or 3. Based on an error of fact. Hodes and Nasser, MDS, PAV. Schmidt, 440p.3 D 461, 469, Kansas 2019. The only judicial discretion utilized in Baby Girl G has been arbitrary, unreasonable, and unacceptable. A fair trial is conducted fairly, justly, and with procedural regularity by an impartial judge. It was the duty of this court to maintain and safeguard the right of trial by a fair and impartial tribunal. Dillman v. Nelson, 178 Kansas 672, 676, Kansas 1955. The preservation of a fair trial, the most fundamental of all freedoms, must be maintained at all costs. Estes v. Texas, 381 U.S. 532, 540, 1965. Petitioner is entitled in full equality to a fair trial by an impartial tribunal. The trial was not fair. This court was not impartial. Due process was not implemented. The judgment and the adoption decree are void. The last time that he saw his daughter, she cried out for him as he walked away. By way of Kansas law, she should have been in her father's custody from square one. Her adoption is void and the law requires that it be vacated. An immediate transfer of sole custody with all essential documentation to petitioner's care must then be ordered. Journal entry. Now on this 16th day of April 2024, the above captioned matter comes before the court for a hearing on the third motion for relief from judgment filed by Pro Se litigant, Paul Allen Fiscus 3. There are no other appearances. The court, after reviewing the file and being duly and fully advised in the premises, makes the following findings and orders. 1. This adoption case was filed September 21, 2018. 2. On October 23, 2018, attorney Melissa Rick entered her appearance for Mr. Fiscus, hereinafter referred to as Fiscus or natural father. Ms. Rick represented Mr. Fiscus up to and through the evidentiary trial. 3. On March 4, 2019, this court held an evidentiary hearing on petitioner's petition to determine whether the natural father's consent would be necessary for the adoption. 4. The court found that based upon the evidence presented at the trial and pursuant to natural father's consent was not necessary for the adoption to proceed and terminated Fiscus's parental rights. 5. Fiscus was appointed counsel for the purpose of allowing him to contest the district court's decision in the Kansas appellate courts. 6. First, Fiscus appealed to the Court of Appeals. The Court of Appeals affirmed the ruling made by the district court that found Fiscus's consent was not necessary / terminating Fiscus's parental rights. 7. Fiscus then appealed to the Kansas Supreme Court. The Supreme Court affirmed the Court of Appeals' decision affirming the District Court's opinion. In doing so, the Supreme Court stated, "Finding no error, we affirm the opinion of the Court of Appeals in its entirety." 8. Fiscus then filed suit in Federal District Court against the adoptive parents. Said case was dismissed. 9. Fiscus then filed a writ of certiorari with the United States Supreme Court, which was summarily denied. 10. On November 9, 2022, Fiscus filed a motion for further consideration on relief from judgment. The District Court reviewed the motion, found it to be without merit, and denied the motion. Additionally, the court sent correspondence to Fiscus advising that I had ruled on and denied your motion. 11. Fiscus appealed that decision to the Court of Appeals on November 16, 2022. 12. On April 4, 2023, the Court of Appeals denied the motion for rehearing or modification and dismissed the appeal. 13. On July 21, 2023, the Supreme Court denied the petition for review and dismissed the appeal. 14. On February 6, 2024, Fiscus filed a motion for relief from judgment. The District Court reviewed the motion and overruled the motion. 15. On March 29, 2024, Fiscus again filed a motion for relief from judgment. Again, the court reviewed the motion and overruled the motion. 16. Fiscus has again filed another motion for relief from judgment dated April 12, 2024. 17. Fiscus's motion for relief from judgment dated April 12, 2024, is denied. 18. Fiscus continues to argue, in each motion that he files, that the District Court's order is void. He alleges that the District Court abused its discretion in terminating his parental rights. The District Court has overruled Fiscus's motions. Additionally, the Court of Appeals and the Supreme Court have also rejected Fiscus's position. Had either appellate court found that the decision to terminate Fiscus's parental rights was arbitrary, fanciful, unreasonable, based on an error of law, based on an error of fact, or void for any other reason, either. One could have dismissed or reversed the District Court. They did not. 19. The 14th Amendment provides a right of access to the courts, which includes access by inmates. Bounds v. Smith, 430 U.S. 817, 1977. This right is neither absolute, nor unconditional. A litigant has no constitutional right of access to the courts to prosecute an action that is frivolous or malicious. Holt v. State, 290 Kansas 491, 500, 232 p.3 d 848, 2010. 20. The Kansas Supreme Court has held that Kansas District Courts have inherent power to impose carefully tailored restrictions on abusive litigants in appropriate circumstances and has authority to direct a District Court clerk to refrain from filing pleadings in such cases. Holt, 290 Can. At 500-02. 21. A judge of the District Court may, upon their own motion, make a determination that an individual is an abusive litigant and make restrictions on filings in a particular case or future cases. The court must first determine whether filing restrictions are justified for a particular litigant. 22. The Kansas Court of Appeals has held a court should consider whether a litigant's pattern of litigation activity justifies imposing filing restrictions, noting numerous factors may be considered depending upon the circumstances. State ex rel. Stovall v. Lynn, 26 Can. App 2 D79, 82, 900, and 7502 D813, 815, Rev. denied 267 Kansas 890, 1999, hereinafter Lynn. Paraphrasing, the court held that a pattern of litigation activity justifies imposition of filing restrictions if a litigant files numerous pleadings, b. the pleadings are manifestly abusive toward the court or another litigant, and c. prior pleadings have not been successful for the litigant. 23. This case is over. Fiscus has exhausted all of his rights to appeal the final decision of the District Court, and his position has been rejected by all of the appellate courts. Pleadings filed with the District Court after the appeals were completed are numerous and frivolous pleadings. Those pleadings are filed solely with the intent to harass and intimidate either the adoptive parents, the court, or both. Fiscus is an abusive litigant. 24. The District Court cannot think of any rational reason to allow Fiscus to file additional pleadings in 18 AD 307 or 18 AD 308. There currently is no remedy at law that would provide Fiscus with the relief that he is requesting. Fiscus shall not be allowed to file additional pleadings unless and until the legislature modifies 59 to 2136 and makes those modifications retroactive to the date of these case filings. 25. The District Court shall review any pleadings Fiscus proposes to file, prior to them being allowed to be filed, to determine whether the condition in paragraph 24 has been met. If the condition has not been met, the proposed pleading will not be filed by the clerk nor heard by the court. It is therefore considered, ordered, adjudged and decreed that the above is and shall be the order of this court. It is so ordered.